I welcome all of you to the Madras Tax Bar webinar series. It is our 145th webinar. The topic today is GST on horse race commissions. Advocate Lavanya Lakshmi will take the webinar today. So it's over to you, Lavanya.
A very good evening, everybody. I'm Lavanya. I've been working with Vaitishwaran sir for the last 3 years now, almost. So before I begin, I would like to thank the Madras Tax Bar for providing me such a big opportunity. I am truly honored and privileged to be here. So my topic for the day is levy of GST on horse race commissions. So this is majorly based on the judgment delivered by the Karnataka High Court in the case of Bangalore Turf Club Limited versus State of Karnataka.
Okay.
So in this presentation, apart from introduction, I would like to introduce the audience to the concept itself. I'll be discussing a few terms, a few definitions, a few interesting definitions. And then I'll be going through the process of horse race betting itself before we move on to the facts of the case. So after which, I'll be speaking about the facts of the case, the contentions, the issues, and the verdict. Apart from all of this, I'd like to also give sort of a brief introduction on online betting and gambling itself, which is the present day problem. Moving on. So the Karnataka High Court recently passed a verdict in the case of Bangalore Turf Club Limited versus State of Karnataka and others. So in this case, the court declared that Rule 31A3 of the Central Goods and Services Tax Rules is ultra vires to the provisions of the Central Goods and Services Tax Act 2017. The court also declared that Rule 31A of the Karnataka State Goods and Service Tax Rules is ultra vires.
No mic.
Oh no. Wait. Okay, so should I start from the beginning? I'm so sorry.
No, we were able to hear it until the beginning of the slide.
Until the beginning. So so the previous slide, were you able to hear me? I don't know why it got muted. I'm so sorry. 1 second. Were you able to see the previous slide?
Yes.
This?
Yes, I think this is the slide that we have to begin.
Yes.
Until the second point of the introduction slide, we could hear you.
Okay. So in this case, the court declared that Rule 31A3 of the Central Goods and Service Tax Rules, as amended in terms of Notification 23/1/2018, that is, it was inserted by this amendment. This was declared as ultra vires to the provision of the Central Goods and Services Tax Act. The court, through this judgment, also declared that 31A of the Karnataka State Goods and Service Tax Rules, which basically mirrors the provision of the central legislation as ultra vires to the provisions of the Karnataka GST Act. So before we move on to the facts of the case, there are a few terms that I would like to introduce to the crowd. So the entire concept of horse racing itself is based on a pari-mutuel betting system. It is a basic betting system in which all bets of a particular type are placed in a pool. This is also known as a tote, after the invention of the totalizator. Now, what is a totalizator? A totalizator is a device which shows the number and amount of bets staked on a race to facilitate the division of the total among those backing the winner. This was essentially introduced to sort of replace the bookies and to mitigate the disadvantages that were caused because of the bookmaker system. However, an automatic totalizator is a device to add up the bets in a pari-mutuel betting system. The whole of the pot, that is all of the money that is bet, is divided pro rata to the stakes and placed on the stakes placed on the winning competitor, and those tickets are paid out. That is, the winning tickets are paid out. Another term I'd like to introduce everybody to is a vigorish or a house stake, which is basically a fee charged by a bookmaker for accepting a gambler's wager. So I'd like to also introduce the audience to the basics of betting in horse racing. So there are simple bets and complicated bets in horse racing. So in simple bets, there's win, place, and show. And in complicated bets, there's trifecta, superfecta, exacta, and quinella. I'm not going to be talking about the complicated bets. We're just going to focus on the simple bets because I want to move on to the facts of the case. So in horse betting, each horse has fractional odds. So the favorite horse will actually have a fractional value, which is basically, it could be less than 1. This is because the favorite horse generally has the least of the payout. So if my horse, if the crowd favorite is horse number 1, it's going to have the least payout. Therefore, it'll have a fractional odd. The long shots, or the horses which may not win, pay more than the favorites. So if horse number 8 doesn't do so well, okay, so if horse number 8 does not do so well, and if somebody bets on horse 8 and it wins the race, the payout for horse number 8 will be more. So the win bet is picking the horse to finish first. The place bet is for when the horse on the horse bet comes second or first, which is, so there are 3 simple bets. There are win, there's place, and there's show. If I place just the win bet, I win the bet if my horse comes first. If I place a place bet, then I win if my horse comes either second or first. If I choose the show bet, I win if my horse finishes first, second, or third. So lastly, there's betting across the board. Across the board is basically combining win, place, and show into one wager. So if my horse finishes first and I've placed win, place, and show, I win all 3 bets. And if I place second, then I win the place and show, and lose win. If I place third, I win just the show bet. If my horse does not come on the first, second, or third, then I lose everything. This is a totalizator board. So the 1, 2, 3, 4, 5 are basically the horse, or the number of the horses. The 5, 2, 6, 10, 3, all of these are the odds that are placed on the horses. The results are declared in the right, and the payout is also given right next to the place at which the horse stands. Moving on to the facts of the case. So the petitioners are a public limited company carrying on the business of a race club, which includes a layout and preparing any land for running of horse races. They particularly conduct horse racing and facilitate betting by punters. Mind you, they actually only facilitate the betting by punters. They do not engage in betting activities. A punter is a person who places bet either with a totalizer run by the petitioners or a bookmaker licensed by the petitioners. Essentially, punter is a person who's placing the bet. If the horse backed by the punter wins, the winning punter is required to surrender the receipt and receive the winning punter. The prize money is distributed by the petitioners to the winning punter. So the totalizator is the facilitators provided by the petitioners, and the prize money distribution is also taken care of by the petitioners. While distributing the prize money, they allocate a certain amount from that prize money as their commission. And this commission is essentially their income in this whole transaction. Up until the year 2017, they have discharged the service tax on the commission under Chapter 5 of the Finance Act and the betting tax under the provisions of Mysore Betting Tax Act 1932. After the introduction of GST through an amendment, Rule 31A was brought to the CGST rules, making GST payable by the petitioners on the amount of bet that goes into the totalizer. That is 100% amount of money that goes into the bet, the pot. According to that was made, GST was made payable on that entire pot according to Rule 31A3 of the CGST rules. So the petitioners filed a case, and the contentions placed before the court were as follows. Rule 31A3 violates Article 246A, read with Article 366(12)A, as it exceeds the constitutional mandate given to the Parliament and the legislature to levy tax only on the supply of goods and services on the principle that if there is no supply, there is no tax. Now, what is the analogy here? What is that supply which is being misread in the rule? Rule 31A3 in effect imposes tax on the petitioner on the entire bet value without the petitioner supplying any bet. So the bet is not supplied as, the bet is not being supplied by the petitioner, and that in fact is being treated as supply under Rule 31A3, thus violating the constitutional mandate of Article 246A. Another contention that was placed before the court is that without assessment of the four components of tax, taxable event, taxable person, rate and measure of tax, imposition of tax, is contrary to law. So the four components of tax are not being satisfied according to the petitioner. Lastly, the impugned Rule 31A3 is ultra vires to Section 7 of the CGST Act 2017, since the supply of bets is not in the course or furtherance of the petitioner's business and is made liable to pay tax. The impugned rule exceeds the mandate under Section 7 by levying GST on the amount that is not received by the petitioner as consideration. This essentially reiterates that their supply is not, they don't supply the bet, they only facilitate the bet. We'll be seeing more of that as we go on. So these are the two issues that were drafted by the court: whether Rule 31A3 of the CGST rules 2017 is ultra vires the CGST Act, whether the petitioners are liable to GST on the commission set apart or on the total amount collected in the totalizator. So what was interesting about this judgment was it had a good flow. So the judgment was very nicely divided into various components. So the judgment, the first talks about the components of tax itself. They cite Govind Saran versus Commissioner of Sales Tax and bring in the four elements of taxation here. Levy, a taxable event, taxable person, rate of tax, measure of tax. They also rely on Mathuram Agarwal versus State of Madhya Pradesh, where the court held that the subject of the tax, the person who is liable to pay the tax, and the rate at which the tax is to be paid should be unambiguously conveyed by the statute. If there is any ambiguity regarding any of these ingredients in a taxation statute, then there is no tax in law. Then it is for the legislature to do the needful in the matter. So these are the relevant constitutional provisions as cited in the judgment: Article 265, Article 246A, and Article 366(12)A. According to Article 265, no tax shall be levied or collected except by authority of law. 246A, as we all know, is the 101st Amendment. And 366(12)A defines goods or service tax. This is the relevant notification, the relevant rate notification. So services provided by a race club or by way of totalizator or a license to bookmaker in such club is taxed at the rate of 14% centrally and 14% in the state. So now I'm going to be talking about the provision itself under challenge. Rule 31A3. Rule 31A3 states that the value of the supply of actionable claim in the form of chance to win in betting, gambling, or horse racing in a race club shall be 100% of the face value of the bet or the amount paid into the totalizator. Now, this is the provision that has been challenged by the petitioner. These are the relevant CGST definitions for the judgment, which is the actionable claim, business, 217(1)(h) of the CGST Act defines what a defines business to include services provided by a race club by way of totalizator or a license to book maker in such club. Section 2, clause 52 of the CGST Act states that goods mean every kind of movable property other than money and securities, but also includes actionable claim. So essentially, the definition of goods includes actionable claim. Sorry, why is there a line over here?
Lavanya, hi. You can actually remove it, or someone might have accidentally done it. There'll be an option to erase.
Okay.
Whoever has by mistakenly done that, you can also erase the thing. Or else you can just stop screen sharing and okay, you've done it. Okay.
It's gone. Yeah, great. Thank you.
Request all the participants not to scribble anything on the screen, please. Thank you.
Thank you. Okay. So this now we're moving on to the judgment itself. So the judgment goes into Rule 31A3. The provision states that the value of supply of actionable claim in the form of chance to win in betting, gambling, or horse racing in a race club shall be 100% of the face value of the bet or the amount paid into the totalizator, which is what we saw right now. It becomes necessary to consider the purpose of Rule 31A3 qua the Act and the components of tax. So the court held that Rule 31A3 in the form that it is perforates the nexus between the measure of tax and the taxable event, as the fully paid value into the totalizator is directed to be assessed for payment of GST under the Act. Therefore, it becomes necessary to consider Rule 31A3 qua the activity of the petitioners, that it becomes kernel of the entire issue. So the court considered 31A3 in lines of the Act and in lines of the business of the petitioners itself. The activity of the petitioners is required to be noticed to consider whether the petitioners are liable to pay tax on 100% of the face value of the bet or only on the commission that it receives out of the amount received in the totalizator. So the judgment itself actually defines what a totalizator is. It means a system of betting. We already saw what the meaning was earlier. But we're going to talk about the software here. The software installed will have number of terminals handled by the staff of the petitioners. The totalizator keeps a record of the amount punted by the punter, as we saw earlier, automatically retains certain percentage towards the commission of the petitioners. It even depicts the amount collected in the totalizator. If you remember the image, if you remember the image, you'd see that the amounts were actually placed right next to the winning numbers, right? Which would be available for distribution among the winner who placed his stake. So a punter who wished to bet pays a certain amount of money through these terminals for backing a particular horse. A receipt is issued representing the monies put in by the punter on the horse he has backed. There ends the work performed by the petitioners through the totalizator. This is it. This is all the petitioners do by the totalizator. The court also refers to an England judgment in the case of toad investors versus smoker. In this case, the court held that the totalizator board can either win or neither win nor lose. Sorry. All they take out of the fund is their expenses. They are merely organizers who receive all the monies in their hands and pay out the total to those who have succeeded, minus the expenses. As they neither win nor lose, it follows that it is not a contract of wagering, nor is it a contract by way of gaming. Therefore, the court held that the function of the totalizator board itself is not a wager. The Court of Appeal held that a contract by a backer who puts money into the totalizator is not a contract by way of gaming or wagering. In the case of Dr. K.R. Lakshmanan versus State of Tamil Nadu, the Supreme Court held that gaming means wagering or betting on games of chance. It would not include games of skill like horse racing. Wagering or betting on horse racing, a game of skill, does not come within the definition of gaming. So not only in the England courts, the Indian courts have also held that horse racing does not fall within the definition of wagering. It is actually a game of skill. Another judgment is of Bangalore Turf Club itself, where the court held that the race clubs further even charge a fixed commission on the said betting. Commission in common parlance has duly been understood to mean a fixed charge payable to an agent or a broker for providing services for facilitating a transaction. Thus, here the court held that it is a fixed charge payable. When it is a fixed charge, it cannot be a wager. The court also speaks a little about the scope of supply, and after which it talks about the application of the same to Rule 31A3. So 7 clause 2 of this section mandates that notwithstanding anything contained in subsection 1, activities or transactions specified in Schedule 3 would neither be treated as goods nor supply. So Schedule 3 talks about the activities or transactions which shall be treated neither as a supply of good nor as a supply of service, under which clause 6 talks about actionable claims other than lottery, betting, and gambling. Thus, the exception to Schedule 3 is lottery, betting, and gambling. They are excluded from activities or transactions which is neither treated as a supply of goods nor as a supply of services. Therefore, this falls within, it's a double negative. So the court held that all forms of supply of goods or services or both for consideration in the course of furtherance of business means a supply. The court also held that the taxable event is the supply, that is supply of goods for consideration and in the course of furtherance of business. So this course of furtherance of business. So here the court talks about the definition of business itself to clause 17 of Fetch to include activities of a race club, as we saw earlier, by way of totalizator or a license to bookmaker in such a club. So we are going to talk about, ideally, the course of business of a totalizator. The court emphasized on the course of business of a totalizator. What is the course of business of a totalizator? So now the court moves on to the function of the totalizator, because the court wanted to examine the course of furtherance of business in terms of a totalizator and not and see to what horizon their function extends to. So what is the function of a totalizator? They do not indulge in betting, as we saw earlier. Petitioners hold the amount received in the totalizator for a brief period in its fiduciary capacity. That's what they were doing. So the court held that the petitioners held the amount received in the totalizator for a brief period in its fiduciary capacity. They hold the amount between the input of money by the participants and the output of money to the winners. They just hold the money during that. They facilitate the race by holding the money during the race in fiduciary capacity. When it's fiduciary capacity, you can't call them owners. or you can't hold that pot to be their income. Anyway, Rule 31A3, the court held that completely wipes out the distinction between the bookmakers and a totalizator by making the petitioners liable to tax on 100% of the bet value. Now, why is the court making a distinction between a bookmaker and a totalizator? So it is the bookmakers who indulge in betting and receiving consideration depending on the outcome of the race, irrespective of the result. In contrast, the race club provides totalizator service and receives commission for providing such service. So the bookmaker actually plays a larger role than the club providing a totalizator service. The judgment is also viewed in terms of consideration. So we've seen the judgment in terms of the totalizator. Now we're looking at the judgment in terms of consideration, supply. And now we're looking at the judgment in the terms of consideration. The consideration that petitioners receive for supply of service of the totalizator is only the commission. The commission is the only, the commission so received by the petitioner is not in respect or in response to an inducement of supply of betting transaction, as we already saw. So the totalizator holds money in trust on behalf of the punter before redistribution to the winner of the stake, which cannot be construed to be a consideration. The money that is held in trust cannot be construed to be a consideration in terms of Section 231 of the Act. So after negating after the court negated that after the court accepted the submissions of the petitioners that it does not come into consideration, it does not fall into consideration, the bet amount, the entire bet amount for totalizator, the court moves on to taxable persons. So the petitioner does not supply bets to the punters. It is the punter who places his bet through the totalizator operated by the petitioner. What is retained by the petitioner is the commission, and the balance amount collected by the totalizator is distributed among based on the winning amount. So this paragraph is important. The categorical statement made in the objections is that effectively, irrespective of the result of the race, petitioners receive consideration in the form of commission. This is exactly the submission of the petitioners, that they are liable to pay tax under the Act for the commission that they receive and not for the entire amount that passes through the totalizator, which is meant for distribution among the winners. Thus, on the very understanding of the government, the action impugned is rendered unsustainable. So here, the respondents actually came up with the argument that by stating the skill lotto solutions judgment recently delivered by the Supreme Court. The skill lotto, but the Karnataka High Court in this case distinguished the judgment delivered by the Supreme Court in Skill Lotto Solutions Private Limited by stating the facts of the case itself. In this, the court held that in the judgment of Skill Lotto Solutions, the issue was concerning a challenge to the definition of goods and services under the Central Goods and Services Act 2017. The challenge of the petitioner was with regard to the hostile discrimination of the three categories of actionable claims, only being lottery, betting, and gambling. So the challenge was in relation to Schedule 6, where the actionable claims excluded lottery, betting, and gambling, and this was claimed as unfair. The question before the Apex Court, as quoted, was Hansard holding that the sale of lottery was an actionable claim, and the taxing the entire amount on the face value of the ticket or of the prize money as notified in the official gazette, whichever was hired was to be paid. Actually, the court held that taxing policy and the taxing statute of various countries are different, which are in accordance with the taxing regime suitable and applicable in different countries. The issue which has been raised has to be answered by looking into the statutory provisions of the Act 2017 and the rules framed therein. That was the judgment. So the court did not want to interfere with the taxing policy of the government in this judgment. So, and the other grounds for upholding it was determining the face value of the lottery tickets for the levy of GST prize money was also determined in the judgment. The court held that while determining the taxable value of supply, the prize money is not to be excluded for the purpose of levying of GST. The court in this case held that the face value of the ticket is known by its publication in the official gazette, which will fall under the Act. The petitioners would become liable for payment of tax under the Act is the commission that it receives for rendering service of holding the bet in the totalizator for a brief period in fiduciary capacity. Here, the court is actually concluding the case. And though in this skill lotto solutions, the apex court had considered what is an actionable claim qua the sale of lottery ticket. I'm so sorry. Yeah. The apex court in this case, the Karnataka High Court in this case distinguished, stating that though the apex court has considered what is an actionable claim qua sale of lottery ticket, that would be inapplicable to this case at hand, as the challenge before the apex court and the answer was on a different fact and circumstances itself. It was not for the questions placed before this Honorable High Court. Therefore, the supply of an actionable claim, as indicated in the rule, cannot include the entire amount brought into the totalizator. So, the final conclusion by the court was that the entire dispute revolves around the Act whether Rule 31A3 runs counter to the provisions of the Act with particular reference to subsection 2 of Section 7. Subsection 2 of Section 7 declares actionable claims to be neither goods nor services except lottery, betting, and gambling. Subrule 3 declared the value of supply of actionable claim in form of chance to win in betting, gambling, or horse racing in a race club shall be at 100% face value of the bet or the amount paid to the totalizator. Therefore, the Act which deals with the supply of goods consideration business would not apply to the function of the totalizator, making the entire bet amount that is received by the totalizator liable for payment of GST would take away the principle that a tax can be only on the basis of consideration even under the CGST. The consideration that the petitioners receive is by way of commission for planting a totalizator. They were only facilitators. The tax cannot be on the entire bet amount in the hands of the petitioner. There can be nothing different from that of a stockbroker. This can be nothing different from that of a stockbroker or a travel agent, both of whom are liable to pay GST only on the income. This was an analogy that was given by the court itself. Therefore, Rule 31A3, insofar as it declares that the value of actionable claim in the form of chance to win in a horse race of a race club to be 100% of the face value of the bet is beyond the scope of the Act. This is also in the light of the fact that the activity of the petitioners being a game of skill and not a game of chance as held by the apex court in the case of K.R. Lakshmi. So the court held that this was a game of skill, one. The second point was, if it was a game of skill, even, regardless of whether it was a game of skill or a game of chance, the totalizator's function was only facilitation. They held the money in a fiduciary capacity, and the commission that they deducted was their only income, and the tax must be levied only on their income. Since they levied the tax only on the income, since the tax is supposed to be levied only on the income, Rule 31A3, which actually levies tax on 100% of the face value of the bet, which they're not in charge of. They don't actually indulge in betting, is beyond the scope of the Act. So the court held that Rule 31A3 travels beyond what is conferred upon the rulemaking authority under Section 9, which is the charging section, by way of an amendment to the rule. The totalizator is brought under a taxable event without it being so defined under the Act, nor power being confirmed in terms of the charging section, which renders the rule being made beyond the provisions of the Act. Thus, consequentially, the court quashed the provisions. The court also quashed the provisions under the Karnataka SGST rules, as we saw earlier. Therefore, the Rule 31A3, which does not conform to the provisions of the Act, will have to be held ultra vires to the Enabling Act and consequently opens itself for being struck down. Rule 31A3 of the CGST Act is struck down. Rule 31A of the Karnataka SGST Rules 2017 is struck down as being contrary to the CGST Act. The petitioners are liable for payment on GST only on the commission that they receive for the service that they render through the totalizator and not in the total amount collected in the totalizator. So with that, I conclude the case as such, but I also want to expand the horizon a little bit. I want to talk about online betting as well. Presently, most forms of betting and gambling are mostly illegal in India. The betting and gambling industry is regulated by the Public Gambling Act of India, 1867. So Tamil Nadu, Andhra Pradesh have vehemently advocated banning all sorts of online betting and gambling. Karnataka, Gujarat, Rajasthan, Madhya Pradesh are also forming similar views. Meghalaya, however, enacted an ordinance called the Meghalaya Regulation of Gaming Ordinance 2021. According to this ordinance, no games of skills or games of chance involving betting or wagering of money or money's worth shall be played, organized, or exhibited by any person without a license. So essentially what Meghalaya government did is they are trying to license this entire industry. They're trying to bring the entire industry in, under control through licenses. They want to regulate it because probably Meghalaya government saw that as a source of revenue. However, states like Tamil Nadu, Andhra Pradesh, Karnataka has recently told Karnataka government has recently told the High Court that they'll be looking into the regulations for online betting and gambling. I think this was in the month of February. And most recently, the last week of May, the Goods and Service Tax Council itself has constituted a group of ministers to examine whether any change in legal provisions is required for valuation of services provided by online gaming, race courses, and casinos. So, in my opinion, the verdict is a conclusion through amalgamation of a number of judgments of various flavors. The court examined multiple judgments and finally arrived at the Rule 31A3, which is it's sort of a conclusive explanation to all of the judgments earlier. So the judgment sets as a good precedent to evaluate the present day online betting and gambling, which is probably why another reason as to why the committee has been set up as itself to reevaluate the GST levy on race courses. However, in my opinion, I think the legislations have to be amended or a new legislation itself has to be created to sort of meet with the demands for the software industries as such, online gaming. So that in my opinion, I would like the legislation to draft a certain set of rules that go in line with online gaming. Like I think the initiative by Meghalaya government was interesting. Instead of banning it, you can regulate it through licensing. And that way it can actually go hand in hand. And I don't see why not. Okay, so that ends my presentation. Thank you. Thank you all for listening.
Thank you, Lavanya. Prithvi here. In fact, I was not there when the session was started. So it was a very good presentation, and like the way you divided the entire concept of horse betting and the judgment of Bangalore Turf Club into various positions, various sections, and then in a very simple way. So I'm sure that this topic will have a lot of views by all our members. So I request our members to kindly come forward to give your opinions, or you can ask your doubts, so that we can have a good discussion on this topic. It's a very interesting judgment by the Karnataka High Court. So the floor is all yours. Vaideshwara sir, good evening.
Yeah, good evening. And Lavanya, good job. Glad to see you make this presentation, and you've done a fair justice to the decision, and you have rightly taken through the facts, which is very critical as far as betting is concerned, because nobody really understands betting. And the way you put across the entire journey of horse racing is quite interesting. And it's very apparent that you've done the research on your own, because had you asked for my help, I would have given very little stuff, because this we had prepared in the early days when Madras Race Club was fighting its appeal. So at that point of time, the online was not that great. So we had our little understanding of the betting process, and the totalizer was just in the scene. And you have really taken through it in a very good way. And just for the benefit of the viewers, it's also good if you can read the K.R. Lakshman case of Supreme Court. It's a very elaborate judgment, and it touches upon multiple issues. And one facet of the case was whether it is skill or not. That aspect is very well discussed in that case. Mr. Parasaran appeared in the matter, and it's beautifully written. You know how difficult is it to predict the winner of a horse? What are the skills involved in horse? What are the skills involved in jockeys? You know, all those aspects have gone in depth into it. And one other trivia, since I saw B. Ravi somewhere in the whole system, he would know this case better. The Tamil Nadu passed the legislature. Tamil Nadu legislature passed an act to take over the club. They passed an act for taking over the undertaking of the Madras Race Club. And that act was struck down by the Supreme Court on the ground that Madras Race Club was a company by itself, very much governed by the Companies Act 1956. And if there are any misgivings in terms of mismanagement or operation, etc., there are remedies under the Companies Act. There is no necessity for a state legislature to enact a law to take over the club for that reason. So it's a definite good read for all the lawyers. Thank you.
Thank you, sir. We will definitely look into the K.R. Lakshman's judgment. Any other members?
Lavanya, Aparna here.
Good evening, ma'am.
That was an excellent presentation.
Thank you.
And you have dealt with the facts and the findings and everything in a very elaborate manner. I'm very glad to say that, Vaideshwaran has got a very good find. I can understand that.
Thank you, ma'am. It's
So, keep it up.
different for me because it's the first time I was doing a webinar.
Of course, everyone has had a first.
Strange too, yeah.
Every one of us has had a first, so don't worry about that.
The webinar, so I just
is
kept getting caught in the screen.
That's okay. No, that is the intention of your, encouraging juniors in MTB, because we want you to do it so that when you go outside and do, you don't get the fear.
Yeah.
Very good.
Webinar was is relatively a new concept for me.
That's okay. That's okay.
Yeah.
You did well.
Thank you, ma'am.
Thank you, Aparna.
Lavanya,
Yes, sir, Ravi, sir. Good
I
evening.
just wanted to compliment you. You really did very well. I know it is very easy to bet on a horse and win the race also, but very difficult to understand the terminologies used in the horse racing. In fact, even without having any experience in betting on a horse in your real life, you have really done a wonderful job in explaining the various terms. Okay, hats off to you. And
Thank you so much.
Really done very well.
Thank you.
Thank you.
Thank you, sir.
Any questions?
Are there any questions? But this judgment actually deals on a lot of issues. Even I tried to read it once, but then in such a short span of time, you were able to like cut short it and phrase it in a very nice, simplified way actually helped a lot. So like the concept of horse betting and the various terminology used by you was really good. Like Vaidishwaran, like Ravi sir said, horse betting is easy to bet and win or to lose, but then to understand the entire concept was really it's really very complicated, I should say, because
Sorry.
as an outsider, people always question what is wrong in taxing the entire the betting amount, the totalizator amount, but then they don't realize what is the concept, what is the law. So that is where the court comes into play and passes judgments and makes it more interesting. So thank you so much for this thing. I see SR Sundar having something to SR Sundar sir.
Hello, Prithvi.
Hello, sir. Good evening.
How are you? Yeah,
I'm fine.
I saw pleasant face of Mr. B. Ravi sir and also Lavanya.
Good evening.
Lavanya, wonderfully done, Sundar here.
Thank you, sir.
And our office is also watching your webinar.
Thank you, sir. I'm so glad.
Yeah, it's very wonderful presentation. And very incidentally, there is a Madras High Court Division first bench case going on, you might be aware of, on the closing of clubs on the game of chance or skill.
Right. Yes.
So all these judgments also been referred to and argued. Good.
Thank
Good.
you.
Well done.
Thank you.
Thank you.
Lavi, probably in the form of a query because you are just expecting some query to come. So can you just draw the thin line between the facilitator and supplier of service? The petitioner you are emphasizing right through, he is a facilitator only. Therefore, the commission is not liable to tax and all. But actually, he providing the service. Is he not doing a supply of service?
No, he is providing a supply of service. There is no doubt about that, sir. But the supply of service was not the placing the bet itself. That is, the betting amount was not his. It was what he did, what his supply was. It was only facilitation. He only ensured he was basically sort of the owner of the automatic totalizator, and he facilitated the entire process. He was not involved in the money pooled in or the money taken out. He was only in charge. His scope was limited to facilitating it and distributing the prize money. So so he had a supply, but the supply defined under Rule 31A3, which is the entire, the supply the rule was trying to tax was the entire face value of the bet, which he was not in charge of. What he obtained was just the commission. So if 10 people, there are 10 people betting on a number of horses, all of their money, say 2 horses, all of their money is pooled into a pot. So that pot is only being guarded. He stands as a guardian or a fiduciary for that pot. So after the race, this pot is distributed to the winning bets. And he is only in charge of taking care of the pot after the bet is being placed and during the race and distribution of the money. He does not place the bet. He's not in charge of the money being put in. The money being put into the race is not his. He's only a caretaker of the money. So his supply is only the money and the tax is only on the money.
Right. Well explained.
Thank you.
Thank you. Any other questions?
Suppose, for example, I am Gokarnation here.
Good evening, sir.
Good evening, sir. Good evening, sir. Madam, your excellent presentation.
Thank you, sir.
The young age, hats off to you.
Thank you, sir.
I just put a question on you. Suppose you take the lottery. Suppose Tamil Nadu government is running lottery. Each lottery ticket is 1 rupees, right? Okay. Suppose there are 10 lakhs people are buying the lottery. 10 lakhs is coming to the pot. Okay. Pot is maintained by the government, right?
Right.
Out of the 10 lakhs, they distribute the price of 5 lakhs.
Okay.
Okay, to the winners. The other are losers. So they are getting the 5 lakhs. Government is getting the 5 lakhs as a profit. In other words, the difference is commission for the government to run the lottery, like that. So can we take the similar stand here also? Suppose for example, in the horse trading, there are about 10 lakhs money collected and put in the pot.
Correct.
So the winner is distributing 8 lakhs to the winners, right? The 2 lakhs they take as a commission. Shall we take
Yeah.
it that way?
Yeah.
So
That commission can be taxed, sir.
can be taxed. Will it be equal to the lottery trading? I'm telling you.
No. So the lottery actually falls under the exclusion of actionable claim, and the entire amount is actually being taxed. The stance of the legislation itself is different here. So according to Karnataka High Court, lottery betting and gambling amount. So the lottery betting and gambling amount itself is the wager, sir. The resultant amount is based on the wager itself. Here, the resultant amount is not based on a wager. It is based on the fixed. So it is based on the initial pot that is being put in. My outcome, my revenue here is not based on the result of the bet. In case of bookmakers, that's not the case, which is why they are actually being taxed on the entire face value, or as per the statute 31A(1) and 2. It is not based on the entire bet amount here. It is only the entire bet. The idea is that my money, the totalizator, has only a commission which is already fixed, regardless of the outcome of the race. In lottery betting and gambling, that is not the case. The commission itself could be based on the outcome of the race itself. The commission itself could be based on the winnings. The entire reason why the precedent had the Karnataka High Court distinguished it is because there is no element of wager here. Is there a follow-up, sir?
Good.
Thank you, Lavanya. So it was a very good presentation by you, Lavanya, today. It was, as I said earlier, that you had dealt the concept of horse betting in a really good way, and like the components of taxations which was involved in the judgment, and how they distinguish the Supreme Court judgment. Everything was very well presented by you.
Thank you.
And then your views on the online betting and how it could be applicable, or how Meghalaya has also got an ordinance to bring about the changes, are all very interesting topics. Like all these things are going to be of great importance in the future. We are seeing something big happening on this side as well. So now let us see where Bangalore Turf Club goes from here. This was a single bench order, and then we'll see how it goes. So thank you to all the participants for joining us, and thank you Vaidishwaran sir, Sundar sir, and Gokarnation sir, and Ravi sir for adding up in this presentation. It was a really wonderful presentation. We will be putting up this in our YouTube channel. We'll share the link once it is uploaded. So thank you all for joining us today. We shall intimate about our next session in the coming days. So thank you once again. Please take care and stay safe. Thank you and have a good day.